So let us consider the question. May the Senate investigate the President in aid of legislation? The answer is no. As held by the Supreme Court in Senate versus Ermita, the President enjoys executive privilege. And executive privilege, as explained by the Supreme Court, may be invoked only by the President or by the heads of office in the office of the President. If so invoked by the President. And in that case, where the heads of office or the subalterns of the President did not consult the President and did not inform the President of the need to invoke executive privilege, they have no choice. They cannot invoke the executive privilege. The requirement is that the heads of office must inform the President of the need to invoke executive privilege, because it is only the President who enjoys that privilege, and which he may extend to his subordinates under the theory of political agency, because the department heads can act on behalf of the President, subject to review, revision or alteration by the President. But as alter egos, they can act and speak for the President. Executive privilege is a privilege vested in the office of the President, which the office of the President may invoke with respect to his subalterns. Let us revisit what was raised by my colleague in the Ateneo Law School, Dean Mel Santa Maria. He said that the President made a colossal ignorance of the law by saying that as Vice President he is immune from suit. In the previous Constitution, before the 1987 Cory Constitution, there is no provision in the Constitution on the immunity from suit of the President. But according to the Supreme Court, that is an inherent power of the President, so that his important functions may not be interfered with. But then, in the case law granting immunity from suit, civil and criminal, while in office, because he is removable only by impeachment, the Supreme Court did not extend the privilege of immunity from suit from the to the office of the Vice President. But in the last session, I read to you the provision of the Constitution that immunity from suit is granted by the present Constitution not only to the President but to the Vice President as well, and to the heads of constitutional offices or independent constitutional offices. Now, I cannot understand. This is already the start of the political season of mudslinging, trying to do demolition jobs, and a matter of due process is involved, because when the Senate is making an investigation, it assumes the role of both the magistrate or the quasi-judicial body that will render a verdict, and at the same time, the complainant, and as a matter of due process enshrined in the Constitution, the investigator, the judge, must be independent and impartial, and must not be motivated by malice, bad faith, or mudslinging intention. Now, in the case of Gordon, he has decided to run for the president, for the presidency. And so he is now a contender. He should wait for the political season for campaigning to air his gripes, or to show that he is better off than his opponents. Therefore, to be an investigator as a senator and to be biased and prejudiced, right away making public pronouncement, concluding or jumping into conclusions that graft and corruption is involved, and the respondents are guilty of graft and corruption right away, without hearing the full evidence. Due process hears before it condemns, proceeds to trial, and renders judgment only after trial. That is due process, based on the evidence. So Gordon should let the evidence speak for itself on the determination of whether the respondents are guilty of graft and corruption. Now, Gordon is a lawyer, and he knows that he cannot summon the president, he cannot investigate the president, even in aid of legislation. I have been watching the Senate proceeding, and there is no mention of any law that he intends to amend or introduce which might justify the investigatory functions that he is doing right now. Now, let us wait for the evidence to be in. Let us give due process. Let us hear before we condemn. And Gordon has already condemned Christopher Lau and the office of the president without even hearing, without terminating the hearing, and conducting marathon investigation where he is testifying. He is the one making the conclusion, and his questions were tilted in a very inquisitorial manner, presuming guilt before looking at the evidence. But anyway, pardon me, but I am very concerned with due process, because I have raised due process in favor of the people, in favor of whoever may have been aggrieved by the gross violation of due process of law. You will recall that in the Aquino-Galman double murder case, I was able to reverse the mass acquittal of the military escorts of Ninoy, and to have, through petition for mistrial before the Supreme Court, a retrial and a conviction. But what is alarming to my mind is, until now, we have not announced to the public who are the real masterminds behind the assassination of Senator Benigno Aquino and in the process of Galman. But anyway, we have seen evidence who might have been. But That is a thing of the past, and I am just raising that because due process of law is something that is very important in an accusatorial form of government where there is presumption of innocence and guilt must be proven by evidence beyond reasonable doubt with moral certainty. And so, as we learn in the pronouncement of the Supreme Court in the case of the PCGG, that the investigation of the PCGG should not be inquisitorial, because there is the presumption of innocence and due process of law must be respected, because an investigator, a quasi-investigatory body like the Senate or the Presidential Anti-Graft Commission must be impartial in the investigation, because as held in that case, an investigative body cannot be the prosecutor and the judge at the same time, because that violates due process of law. Due process requires an impartial and independent investigator, and the investigator cannot be prosecutor and the magistrate or judge rolled in one, because that violates due process of law. And I believe that during the period of the past approaching political campaign, investigation like this should not be tolerated, because definitely I agree that this is a question or a matter of grandstanding to call attention to himself, and that has a time and place for that during the campaign season. So, in the Makbar, what is the remedy? Of course, I am not the Solicitor General. If I were the Solicitor General, I will file a case for prohibition against the Senate investigation in the Supreme Court. And we have precedents to this effect. When Cocoy Romualdez was being investigated in the Senate, and there is no law mentioned that needs to be amended or legislation envisioned to be enacted, and the Supreme Court enjoined the Senate investigation for not being in aid of legislation. Now, I am not prejudging whether the investigation is in aid of legislation or grandstanding aid of ambition. I am not making a judgment, but I am just wondering, why only now? Why is it being done only now? And if you will watch the investigation, Gordon, even in his public interview, has already jumped into prejudgment and conclusion that there is massive graft and corruption. And he even announced in his public interview that he will investigate the president. Maybe he has not read the case of Randy David versus Gloria Macapagal Arroyo. A president is immune from the investigatory, from any suit, civil or criminal. And that includes investigation by the Senate. He cannot be investigated by the Senate because the only way to remove him is by impeachment. Now, please pardon me if I jump from one topic to another, because I believe that a good lecturer, particularly in pre-bar, should be able to correlate, integrate, assimilate branches of the law, because the solution might not be in one subject, but it may be found by way of an exception in another subject. And I have illustrated that in the case that I handle for estafa through falsification of public documents, where I obtained an acquittal on the basis of the definition of forgery or falsification under Section 23 of the Negotiable Instruments Law. Now, let us connect the discussion on impeachment, because the President is removable only by impeachment. He cannot be summoned, he cannot be investigated by the Senate, because he is entitled to immunity from suit. And as I have pointed out, even the Vice President enjoys immunity from the present Constitution. Let us now excuse me, go to the seeming conflict between the provision of the Constitution on impeachment, because the President and heads of the constitutional offices, members of the Supreme Court, are removable only by impeachment. How come that the Supreme Court ousted the sitting Chief Justice Lourdes Sireno by way of quo warranto, when the Constitution is very clear that as Chief Justice, as member of the High Court, Sireno was removable only by impeachment? And in the case of Randy David versus Ermita, the Supreme Court held that the only way to remove the President is by impeachment. He is an impeachable officer under the Constitution. Why was Lourdes Sireno ousted as Chief Justice of the Supreme Court, when by express provision of the Constitution, he is removable only, being a sitting Chief Justice, a member of the Supreme Court, only by impeachment? This is the reason, which is not found in the decision. The decision says that Sireno is unfit to be Chief Justice. She is not qualified because she violated the law on transparency, the law requiring transparency in public office, because she did not include in the statement of her assets and liabilities the 34 or 38 million she earned as a private lawyer, which she rendered in favor of the government. Now, that is another issue. And the issue goes into the integrity and honesty of Lourdes Sireno. Now, I am just quoting the language or the decision of the Supreme Court. She was not qualified to be Chief Justice, and therefore she is removable by quo warranto. How about the issue of impeachment? Sireno was an impeachable officer and may be removed only by impeachment. This is not in the decision, but as a student of equity, I have studied the rules of equity obtaining in other countries, particularly in England, where there is a court of law and a court of equity. The Philippine legal system is both a court, we have both courts of law and equity. So we have the supervening event doctrine, that where a decision of the Supreme Court, which is final, immutable, and unalterable, may be modified if you can show facts and circumstances happening after the finality of the judgment that would render execution of a final and executory decision inequitous, unjust, unfair. Then, as a court of equity, our courts may modify and alter the final judgment to conform to the facts and to serve the paramount interest of justice. And so, in equity, even without Section 1, Article 8 of the Constitution, Philippine courts have the inherent equitable judicial power to review acts of the executive and the legislative, their subordinate agencies and instrumentalities, acts which are tainted with grave abuse of discretion. And even without Section 65, it is an inherent power of the court to review and rectify and correct acts tainted with grave abuse of discretion, tantamount to lack or excess of jurisdiction. So, under the equitable power of any body like the Supreme Court has the inherent power to police and protect itself against rotten members and to remove them, even without resorting, even with the presence of the provision of impeachment, because that is an inherent power of any body. And if you will remember in history, the case of Tañada versus Cuenco, where the power of removal is not vested in Congress, but Congress itself has that inherent power to remove an errant member or senator. And so, to my mind, that is the justification why Lourdes Sireno was removed even not by impeachment, despite the provision of the Constitution on impeachment. Because in a country, common law country, like the United Kingdom, where the judgment of the court of law is unjust, unfair, or inequitous, it might be reviewed by the King's Court of Equity. And the courts of equity, as in our case, may alter a final and executory judgment to conform to the facts under the supervening event doctrine to serve the paramount end of justice. In the case of Lourdes Sireno, in the Piatco cases, she rendered legal services as a private lawyer, and that is not allowed under COA regulation and under the Constitution, because public funds may be disbursed only upon allocation of Congress, and the government is not authorized to engage private lawyers and pay them legal fees from public funds, because that is prohibited by the Constitution. There is no allocation by Congress of public funds to be paid to private lawyers. But like I said, for every rule there is an exception, and it may be justified under the exigency of the situation. And what do you mean by exigency of the situation? Let me illustrate what is meant by exigency of the situation. Extraordinary situation calls for extraordinary solution. During the state of rebellion, warrantless searches and seizures and arrests were justified under the exigency of the situation. Because if you will get a search warrant or warrant of arrest before you can make arrest not justified under the rules of court, where a crime is being committed or about to be committed in the presence of the arresting officer, or a crime has in fact been committed and the arresting officer has reasonable ground to believe that the person to be arrested is probably guilty or is the author of the crime. Without any of these justifying grounds, the Supreme Court, under the principle of exigency of the situation, allowed warrantless arrests and seizures during the state of rebellion. Now, let us connect that with what is happening now. Because of the surging COVID-19 pandemic, this is an extraordinary situation. And purchases might be extremely necessary by reason of emergency. Let us hear first the respondents. And let us not be inquisitorial, concluding guilt before hearing the evidence. That is a gross violation of due process. There is a time for that, for Gordon to speak his piece. Not this time, because the President has already invoked executive privilege. Please stop the investigation because you are interfering with what we are doing. We can do that later on, or you can file the necessary complaints in the NBI, in the CIDG, or to my mind, If the citizens wish a truly independent body, then a citizens commission might be organized by the public, but the public is not doing that. Now, the president is organizing a commission to investigate this. And then the detractors of the administration are saying, oh, that will be a whitewash. Why don't you put up your own? Make an investigation and then file it with the proper agency. Now, I remember when the Presidential Anti-Corruption Commission was proposing to the NBI to investigate Lene Robredo for interfering or dipping her hand in the response against the COVID pandemic. I came out with an article that the Anti-Graft Commission in Malacanang has no jurisdiction over Lene Robredo because the jurisdiction of the Presidential Anti-Graft Commission is limited only to presidential appointees. And I posted that in my Facebook. The following day, the guy in the Presidential Commission, Anti-Graft Commission in Malacanang, was sacked by the President, dismissed by the President. And when the NBI called my attention, I told them, I am not criticizing you. You were requested, but it is, of course, subject to your discretion. And you also have a semi-adjudicatory function to determine whether your investigation is in accordance with the law or not. So we became friends. I was even invited to see them on a social basis, but I cannot do that because it is a pandemic. Now, going back to consultancy in the government, if it is an engagement of legal services of a private lawyer, that is, as a general rule, prohibited. But under the exception, exigency of the service, where no government lawyer is available for a particular legal service, then under the exigency of the service, a private lawyer may be paid with public funds. And an example of that in jurisprudence is in the case of the municipality of Pililla, the lawyer of the municipality is the provincial fiscal. So there is an administrative or civil case involving the municipality of Pililla. And the engagement of a private counsel to represent the municipality and the payment of legal fees to the private lawyer was justified under the exigency of the service, because if a private lawyer would not be engaged by the municipality of Pililla, it would be declared in default. It would suffer. So the exigency of the service justifies the hiring of a private lawyer. Then you may be wondering, why am I, as a private lawyer, involved in some legal services? For example, during this administration, I was the confidential legal consultant of the presidential advisor for Southern Tagalog, rendering legal advices and legal services as assigned to me by the late Secretary Dennis Hernandez. But that is not prohibited because I am not accepting executive compensation. And former presidential advisor Dennis Hernandez had an executive compensation of 1 peso a year. He is even spending his own money in serving the president. Now, going back to public funds might not be dispersed for legal fees of lawyers as a general rule. Then you might be wondering, I have been confidential legal assistant of the city of Lipa, Mayor Sabili, handling cases for him in the Sandigan Bayan, the Court of Appeals, and the Supreme Court. And I have been a consultant in the office of the mayor in Parañaque, as well as in Manila when Arap was the mayor. If the services rendered is not legal, representing the city or the municipality, and the engagement as a consultant is justified by exigency of the service, then compensation may be paid to a private lawyer. In the case of former Justice Tony Carpio, his law firm, the law firm that he established, which flourished in the past several administration. I have a pending case in the Supreme Court which has not been acted upon by the High Court to disqualify them from representing the Central Bank of the Philippines in the Bangko Filipino cases. What happened was that Bangko Filipino was closed by the law office on behalf of Central Bank. And because it is sub judice, I would not say without due process. Now, they have been paid in billions of pesos by Central Bank, and not only by Central Bank, by the other agencies of the government, which to my mind is violative of the principle that public funds may be disbursed only for public purpose as allocated by Congress. And even Central Bank or BSP has admitted having paid attorney's fees in billions of pesos to the firm. And until now, the firm is the counsel of Central Bank, being paid public funds. Never mind if the Central Bank is an independent body, it is still government funds that are involved. But the Supreme Court has not acted on the case. In the previous cases, cases in the lower courts have been decided in their favor because they are afraid of the lawyer representing the firm, because they are perceived to be influential during the past several administration. I will discuss that later when I discuss graft and corruption in the judiciary. But before I leave Tony Carpio, he was a sitting justice of the Supreme Court, and he was meddling with private cases of his law firm. And I know that because I represent the other side, where he would call the sheriff, threaten the sheriff, and of course the sheriff was afraid. And if necessary, I can present evidence to that effect, or I can even testify. Because during the economic crisis, when most of the banks would be attracted to be represented by the firm, I was then lawyer for Commercial Bank of Manila under Lolong. I resigned to handle cases of borrowers from the bank, and I was conducting a seminar on how to protect mortgagors from foreclosure. I was handling seminar for the global best practice, where I was the only speaker the whole day on credit transactions. And there was even a moniker given to me that I was a foreclosure buster, because it is only our office who specialized in agrarian cases and corporate rehabilitation cases. So big firms in Makati would come to us on rehabilitation proceedings, rehabilitation cases, suspension of payments, and agrarian cases, because we were the only ones specializing in those fields of corporate suspension of payments and rehabilitation. And I was conducting seminars, and can you imagine clients lining up in my office to suspend payments because of the Asian crisis. But anyway, I am saying this because banks like BDO and other big banks foreclosing borrowers were mostly represented by the firm, and the borrowers would come to me. So I am on the 7th floor of the LTA building of Mike Arroyo and Gloria Macapagal Arroyo on Greenbelt, and they occupied most of the floors at that time before they transferred their offices. So our respective clients come and go, passing through the corridors or the ground floors of the LTA building. And one case that I remember, because when the position for Chief Justice was vacant, Tony Carpio was interested, and of course my townmate Renato Corona was interested. When I was the Senior Vice President for Legal of the Commercial Bank of Manila. which was a subsidiary of JSIS at the time. Chief Justice Renato Corona was only a mere manager in the bank when we first met. I resigned when Ninoy Aquino was assassinated in 1983 to join my wife, counsel for Cardinal Sin, Jimmy Ongpin, and the 29 opposition civic-minded citizens. And that's why I happened to handle the Aquino-Galman double murder case. Now, so when I put up my law office, I bought a unit in the 7th floor of the LTA. If the bank would be represented by the firm, the borrowers would come to me to represent them. Now, most of the judges in Metro Manila are in their favor. So much so that even the Supreme Court, during the time of Chief Justice Ray Puno, came up with a circular outlawing extrajudicial foreclosure of real, outlawing injunction against extrajudicial foreclosure sale. Now, this is we are now crisscrossing to commercial law. Under this special circular, an injunction against the bank to restrain extrajudicial foreclosure is, as a general rule, prohibited. And judges who would restrain extrajudicial foreclosure would be suspended or removed during the time of Chief Justice Ray Puno, who is very friendly with the banks. The only ground in the circular to restrain a foreclosure is, number one, if the mortgage indebtedness has been paid and a receipt of payment may be presented. And number two, if the ground is the interest is exorbitant and there is a violation of equality between the lender and the mortgagor borrower, because the rate of interest is imposed unilaterally by the bank. So that is illegal, because that is contrary to equality or parity of right. And under the circular of the Supreme Court, which is presently effective until now, the mortgagor may enjoin the extrajudicial foreclosure by updating payment of the interest at the legal rate. And the legal rate is 6% per annum, starting July 1, 2012, as held by the Supreme Court in the case of Bayani Andal versus PNB. And the most and the unkindest cut of all is that where extrajudicial foreclosure may be enjoined on the grounds aforesaid, the bond for writ of temporary restraining order or injunction must be equivalent to the amount of the indebtedness. And as you know, to get a bonding company to give you a bond, you must pay or deposit the amount of the bond. So, if the borrower has that kind of money to obtain the bank by depositing the amount of the indebtedness to the bank, then the borrower might as well pay the bank. But of course, there is default because the borrower suffers from business reverses and is not financially in a position to pay. So, that is what we have in the Supreme Court now, which to my mind is a species of graft and corruption, favoring the banks. Going back to Tony Carpio, of course, he was my rival. I am with the Scintilla Juris fraternity. I was a founding member, chartered member, and he used to be Grand Archon. And of course, we were rivals in the campus between two fraternities. When he was aspiring to be Chief Justice, let me continue with my narrative. During the time of Gloria Macapagal Arroyo, I was even recommending him to be Chief Justice because he is the most qualified and the most senior. But then, as narrated during the last session, I filed a case for mandamus against the JBC to send to the President nominees for Chief Justice during the period when there is a ban for appointment. Again, I put in my petition that while the Supreme Court literally prohibits the appointment of by the President during the election ban 2 months before the national election, again, under the principle that extraordinary situation calls for extraordinary remedy, I made a research and found in a decision of the Supreme Court that the reason for the ban is so that the judge, what was involved was an RDC judge, may not be able to interfere or influence the outcome of the election. And saying and invoking spirit over language, intent over verba lehis. anima lehis against verba lehis. I argued in my petition that the ban does not apply to appointments to the Supreme Court because the Supreme Court has nothing to do with the election. And that was the basis why I won that case. Although I am not taking full credit for that because it was actually Tito Mendoza who appeared in the Supreme Court because I was prevented from appearing in the Supreme Court because I was delayed in a hearing in Batangas. And so I was not able to appear because apparently the judge was mad at me and dismissed the case because I was late and did not even tell me what had transpired while I was waiting there the whole morning until 12 o'clock. But anyway, I do not take it personally against the judge. So the rest is history. Because of the petition for mandamus against the JBC, Chief Justice Corona was appointed by President Gloria Macapagal Arroyo during the election ban. Now, while we are at election, I want you to know what are the grounds for failure of election. Because I have so much on my plate, just read my book. I summarize it there. So let me just go forward. And I believe that because Tony Carpio was biased against me, personally against me, all my cases before him in the Supreme Court, I lost. And in one case, where the appeal under Rule 45 was in his division, I already got a resolution giving due course to my petition. This is a criminal case. I remember the case, People versus David Rondero. It is a murder case. The decision of the Court of Appeals, I appealed to the Supreme Court under Rule 45 on pure questions of law. I was granted due course in a resolution giving due course to the petition and requiring the parties to submit simultaneous memoranda. Lo and behold, during the time that I was that I filed the petition for mandamus in the Supreme Court, I lost the case. How? A resolution, minute resolution came out dismissing my petition. And that is, dismissing my petition or denying due course to my petition, which has been given due course. So, I filed a motion for reconsideration. What can you expect to one who has already prejudged my case? And to me, that is highly irregular. So, in subsequent cases where I am counsel and Tony Carpio is in the division, I would move for his inhibition, and he is sport enough to inhibit in my future cases. Meron kasing akong estudyante sa kung minsan daw ay natachapsuy ang aking lecture. Pero sinabi ko, I have to correlate. And a good lecturer should be able to correlate the different branches of law. People are wondering why I teach all the 8 subjects. Since I became a lawyer in 1970, I already geared myself to be a teacher and a bar lecturer. So I came out with prognosis, or I would say forecast on what might be asked in the bar. That was in 1971. And I published my answers to the 1970 bar and with updates on Supreme Court decisions, even at that early time. And I believe that a good lawyer should not be a specialist, because the solution, for example, I am a business lawyer, commercial lawyer in Makati, corporate lawyer, but I specialized in criminal law because I believe that the solutions and remedies might be found in other branches of the law, as I have illustrated in that criminal case where negotiable instruments law became my effective defense against falsification of a check. Now let us go to the case of Pacquiao. Last night, I was listening to the interview of Pacquiao with Karen Davila. So Pacquiao started all this hullabaloo in the Senate, and before he left, he said he would have the Blue Ribbon Committee investigate the Department of Francisco Duque, Secretary of Health, for graft and corruption in the disbursements of multi-billion funds in response to the COVID pandemic. He started it all. And now we have Gordon, we have Ping Lacson, who are running for president, and others who are detractors of the present administration doing the investigation in the Senate. Now, the last question, or rather, the first one of the questions of Karen Davila is this: will you participate in the Senate investigation? And Pacquiao said, yes. After my quarantine, I will participate by Zoom. Now, let us revisit the case of Danding Kuwango versus PCGG. When Danding was being investigated by the PCGG for ill-gotten wealth, the complainant was the PCGG, the investigator was PCGG, and the quasi-judicial body would be the PCGG to file the case. And the Supreme Court restrained the investigation against Danding Kuwangko on the ground of due process of law. Because the PCGG cannot have the role of an investigator, a complainant, and a quasi-judicial judge all at the same time, because that will violate due process. A cardinal rule in administrative investigation is that the investigator, whether an administrative agency or anybody like the Senate, must be impartial in the investigation and must observe due process of law. It hears before it condemns. It proceeds to trial and renders judgment only based on the evidence, to let the evidence speak for itself, because we are an accusatorial system where there is presumption of innocence and there is a cardinal rule of the opportunity to be heard, due notice and opportunity to be heard before rendering a judgment of conviction. To my mind, Senator Pacquiao is disqualified from participating in the investigation which he himself started as before he left for abroad. And he might be, or for that matter, the Senate might be enjoined by the Supreme Court for number one, violation of due process, from conducting further investigation, particularly that it is now nearing the fast approaching campaign period. They should wait. They shall not be prohibited in a free-for-all, open discussions during the campaign. But Senator Pacquiao, being the complainant, may testify and present his evidence, but he might be subject to probing cross-examination questions. And in the Senate, the lawyers of the respondents are not allowed to talk. I have been in many Senate investigations before, and the lawyers are not allowed to talk. The lawyers may advise the respondent, but they are not allowed to talk. But I have a way of going around that. So when a big tax case is being investigated, the Fortune Tobago case, and I was represented the other tobacco company, what I did was to get a resolution designating me as the authorized representative in the Blue Ribbon Committee. And so I attended, not as a lawyer, but as an authorized representative. And so I was able to speak up, and I was able to cross-examine the guest or those who were presented to testify against my client. Again, that is violation of due process. Can you imagine damning testimony are being presented, and the resource person cannot be cross-examined by the respondent, and only the senators who are biased, who are asking tilted questions, are allowed to examine. Again, due process of law. And if the senator is not impartial, independent, and is jumping into vagrant conclusion, not supported by visible means in the evidence, then they are disqualified from conducting a fair and unjust investigation for being violative of due process that hears the other party before passing a judgment. So I believe that Pacquiao, as complainant and as witness, may not participate as senator to investigate the executive in the response to the pandemic. If they have evidence that they can have it be investigated by the NBI, by the CIGG, and if they wish, they can put up a people commission where interested parties supportive of the administration may participate, so that there will be balance in the investigation, where everybody can present evidence. I remember that one time when the Westinghouse case of the nuclear plant in Bataan was in question in the public eye, there was a commission supposed to be organized by then President Marcos, where the opposition lawyers were appointed to be members of the commission. I was not an opposition lawyer at that time because I was with Lolong Lazaro in the legal department of Malacanang. But Rene Sagisag invited me to be a member of that commission to investigate the Bataan nuclear plant, the Westinghouse alleged anomalies. Although it fizzled out, it did not materialize. But if they wish, Gordon may organize a people's commission, and I volunteer to present, to be a part, so that there will be due process, so that there will be no jumping into conclusion, vagrant because unsupported with visible means in the evidence. Now, for those of you who are listening, my students of law and those who are about to take the bar and who are interested in the current state of the law, let me tell you that I am a private lawyer. I am an independent lawyer. I am for the truth, and I am impartial. But we have to support the administration. That's why I have been supportive of the administration. But at the same time, I am doing constructive criticism. Definitely, I am not part of the present administration because my boss Dennis Hernandez has passed away, and so my designation as confidential legal assistant, honorary confidential assistant with no compensation, has already ceased and has terminated my service to the government. But I still do public service in my capacity as General Counsel for the Task Force Humanitarian for Peace and Order under General Luntok for the Federal Party of the Philippines, which is quite supportive of the present administration. Going back to executive privilege, what is happening in Congress? Let me just
What do you want me to
give me my red book. I put in my MacBar that you take a look or read the case of Randy David versus Arroyo, because the Supreme Court discussed executive privilege in that case. Now let me read the summary of that case. Anyway, the summary is this. The Senate has the absolute right to call department heads under the executive department in investigation in aid of legislation. There must be a specific law envisioned to be amended or to be enacted to justify that power. And even where it is actually justified as an investigation in aid of legislation, the Senate cannot investigate the President because he enjoys immunity from suit. And as I have discussed in the present Constitution, the Vice President also enjoys immunity from suit because he is likewise removable only by impeachment. That is a new provision in the 1987 Constitution because the immunity from suit is not provided in the prior Constitution but also by case law, by decision of the Supreme Court, and it is justified by the exigency of the service that his functions as President should not be interfered with by investigation or by civil or criminal prosecution. Now, what is the exception? Executive privilege. What is the meaning of executive privilege? That is the right of the executive to withhold confidential information bearing on paramount national interest, and more specifically, if it involves security, matters of security. Example of executive privilege: closed door meeting cannot be divulged to the public because that is covered by executive privilege. And that was the case of Neri. Now, to invoke the executive privilege of the president so that it may be extended to the subordinate officers in the executive department, the department heads must inform in advance the president of the need to invoke executive privilege. And I think that in this particular investigation in the Senate, the president must have been informed because he is the one invoking the privilege. Now, if the department heads did not inform the president by estoppel, by failure to inform the president, he is called. He cannot invoke it by himself because it is only the president who can invoke it for him. And so, that is one requirement. The head of office must inform the president of the need to invoke the privilege. And the president is invoking that by saying, stop this investigation because this is interfering midstream in the response to the COVID pandemic. And actually, the opposition is rallying the people to hate the administration. And that is by means of this inquisitorial investigation, jumping into conclusion that there is massive graft and corruption without hearing the evidence and without even finishing the investigation. I have not heard Gordon in the marathon. He is long-winded. He talks too much. But I did not hear him that it is in aid of legislation. What particular law does he want to amend or to enact? It is actually a continual attack on the administration because he is running for president. He should not do that. He might be restrained by the Supreme Court. The problem now is, again, let us go to political law. Political law and even law and procedure. When I was younger, the rule is different. As long as disbursements of public funds are involved, a taxpayer and a private citizen might file a case involving public interest, and that is usually entertained by the Supreme Court. But this time, the Supreme Court has adopted the direct injury and personal interest involved on the question of capacity to suit on public interest cases. And that is exemplified in the recent case that I filed when Pantaleon Alvarez and Tito Soto were quarreling on the interpretation of the Constitution, whether the amendment or revision through Constitutional Assembly should be approved by each house voting separately or in a joint session together. That is a very current, actual controversy. But then, the Supreme Court, adopting the recent policy of direct injury and personal interest, not the general interest shared with the public, to be vested with legal personality to sue, my petition was denied on the ground that the Supreme Court does not issue opinion and must decide only where there is an actual controversy involving real parties in interest. So maybe the Solicitor General, because the President is assisted by able lawyers, may get an injunction from the Supreme Court against Gordon and the Blue Ribbon Committee, because that is derailing the response to the COVID pandemic. And again, let the investigation be impartial on whether there was overpricing or not under the exigency of the situation, where it is of extreme imperative emergency, because acquisition, government contracts without bidding is justified in case of extreme emergency under the principle of exigency of the situation, that extraordinary situation calls for extraordinary solution or action. Equal protection of the law. I think I have discussed in the past the favor granted by law to banks as compared to lenders who are non-banks. And let me just summarize what we discussed before. In extrajudicial foreclosure, where banks are involved as lenders, banks are favored by the law, because under Section 43 of the General Banking Act, the right of redemption, where the lender is the bank, is equivalent to the amount of the indebtedness as appearing in the promissory notes and the mortgage documents. Now, compare that under Act 3135, where the lender is not a bank, the amount of redemption, which is within 1 year from the registration of the sheriff certificate of sale, is the bid price plus reasonable cost of money and other imposition by the government. Oh, can you see the difference? The bank is favored, and anything that discriminates in favor of a party violates equal protection of the law. And I have raised this in many cases, but it has not been resolved by the court. And again, on the period of redemption, where the bank is the lender, the period of redemption is not from the registration of the sheriff certificate of sale. It is from whichever comes first. Registration of the certificate of sale. So once the certificate of sale is registered, there is no more right of redemption. or if the sheriff certificate of sale is not recorded in the register of deeds, then the right of redemption is 3 months from the date the auction sale is conducted. 3 months. After the lapse of 3 months, there is no more equity of redemption. Now, compare that with the right of redemption under Act 3135, where the lender is non-bank. The right of redemption is 1 year from the registration of the sheriff certificate of sale with the register of deeds. So that is a definite advantage and favor to the lender bank, which to my mind is discriminatory and a violation of equal protection of the law. Now, difference in treatment by way of an exception is allowed when there is a substantial distinction that would justify a different treatment. So, a treatment of a particular class may be different from other persons because of a possible distinction that justifies the differences in treatment. And I'm sure you will come across this in your review of constitutional law. Still on the equal protection of the law, let us go back to the issue of isabong. As it is now, during pandemic, the rich people who are allowed to conduct or operate isabong because they can afford the very high cost, only those who are authorized by PAGCOR to operate online sabong can conduct sabong. Just yesterday, there was a online sabong within Manila. While Manila is under modified, enhanced community quarantine, where there is a strict protocol against social distancing. To be able to operate online sabong, you must put a bond, 75 million with PAGCOR, and you must pay license fee of 12,500 pesos per fight. And the minimum fight per day required by PAGCOR is 200 fights. Now, if you multiply 12,500 by 12,500 pesos per fight by 20 fights, and you include the cost of allowances to be given to the participants, the minimum cost per day of online operation is not less than 10 million pesos a day. You multiply that by 30, 300 million. That is the cost per month. If you are starting in online sabong, not many can operate, can afford that. And so, there is now a discrimination based on poverty. Only the rich people can operate online sabong. Now, luckily, I have been invited to be president of the World Slashers Alliance, a group that is putting up online sabong who can afford to fund the operation. So let us see if we can do that. Because the purpose of this group is to level the playing field, to give opportunities to small breeders and cackers to be able to participate in online sabong under the same terms of the online sabong of Atong Ang. Actually, I have nothing against Atong Ang. He was my friend and we started in sabong almost practically together, although I am older than him. I even state in my public pronouncement that without online sabong propagated by Atong Ang, the sabong industry would have been dead because of the COVID pandemic. And with online sabong being conducted by the Pitmaster Group and other groups who can afford to put up the capital, the sabong industry is now alive. Breeders are breeding again. Because without the online sabong during the pandemic, the sabong industry would have been dead. But I believe that once the pandemic is gone, sabong industry will be back to normal because regular cockpits will be open. And when social distancing is no longer strictly enforced, then we can have the regular traditional cockfights. And actually, under the policy of the IATF, sabong has been reopened during GCQ under strict health protocols. But because of the surging COVID-19 pandemic, now the government allows only sabong, strictly and limited to PAGCOR licensed online sabong. Last time, I distinguish between a license fee and a tax. I am not taking that back because the taxing authority is vested in Congress. PAGCOR, by and in itself, has no taxing power. It is a mere regulatory agency. And a license fee, as distinguished from a tax, must be reasonable and must be limited only to the necessary expenses to regulate. But this is an extraordinary situation. The government has come up with steep requirements to operate online sabong, which anyway is doing very well, profitably, because of the exigency of the situation that we are in dire need of funds to respond to the COVID-19 pandemic. So I will classify the action of PAGCOR as justified under the exigency of the situation. Because in the field of equity, what is important is the respond to extraordinary circumstances or situation justified by the doctrine of exigency in public service. So nobody will question PAGCOR at this time because it is justified by the exigency of the situation that the government has to raise funds and for a noble purpose. And what I mentioned last time is you may consider it as a de facto taxing power exercised by PAGCOR, justified under the exigency of the situation. Because the operative fact is that PAGCOR is issuing license, and those who have been issued PAGCOR license may operate online sabong subject to the health protocols and to the requirements of PAGCOR. And there is no violation of equal protection of the law because everybody who can comply with the requirements of PAGCOR are free and allowed to operate online sabong. But under the exigency of the situation, I believe that tupada should not be prohibited now, especially now, with a strict lockdown protocol. Tupada should be allowed, and the barangay captains in the various barangays should be authorized to put up barangay cockpit so that the people in the barangay, the small people who cannot afford to play in the online sabong, may exercise their freedom to the pursuit of happiness, which is guaranteed by the Constitution and by the Universal Declaration of Human Rights of the United Nations, without discrimination based on poverty, color, creed, religion, etc. Because we should also consider that these small cockers have the right to pursue their happiness. They, instead of playing in talpak, which you cannot win, it is really something that you cannot win because the kaltas or commission is so big. And even if you win most of the fights, you will lose your money because most of the money being played are not given to the players. And what is even worse is that even women who do not do anything because it is pandemic, and even minors are addicted to playing talpak. So if Tupada will be opened in the barangays, then people, common people, may engage in sabong. But anyway, my friends in the sabong industry, kayo po ay nasa aking puso. At kayo po, lalo yung mga maliliit na breeders at magsasabong, ako po ay kasama ninyo. At ako po ay naniniwala na kung tayo po ay mag-iingat, let us observe the strict health protocols. Huwag po tayong magtipon-tipon dahil isa lamang may sakit ang makasama natin sa pagtitipon-tipon. Lahat ho tayo ay mahahawa. Nangyari po ito sa isa kong kaibigan na nag-birthday party against the health protocols. Ay may isa pong bisita na may COVID. Lahat po sila nagka-COVID, buong mag-anak. At ang mahirap ho nito sa COVID variant ay pati ho mga bata ay tinatamaan. Ay di ngayon, silang mag-anak ho ngayon ay na-COVID. At tungkol naman ho dito sa COVID, ako po ay COVID survivor. So by way of intermission, let me tell you my story as a COVID survivor. Noon pong bagong magka-lockdown dahil sa COVID, ay inisip ko na ako wala naman sakit, ay bakit ako ikukulong? This is a violation, a deprivation of my liberty without due process of law and without a ground. Because I am not sick. Hindi bali nakako na ipa-test, and I was advocating massive test at i-identify yung may sakit at yun na lamang ang i-quarantine at pabayaan itong mga walang sakit na lumabas. It is their free choice. Kung gusto nila mag-quarantine, natatakot sila, let them stay home. At kung hindi naman, ay let them go out. So I went out. Nagtagal-tagal po hanggang noong April 24. Ako po ay may isang kaso sa Tanawan. Pinuntahan ko yung co-counsel ko at iginawa ko ng pleadings. Kasi marami po naman na nagpapatulong sa akin. Dahil siguro well-versed ako sa law and jurisprudence at mabilis po akong gumawa ng pleadings, ay di ginawa ko ng pleading yung aking co-counsel. I stayed there for 30 minutes. Doon po ako na-COVID. Kaya naman ako na-COVID, tumuloy ako sa farm, ay nakasara po naman yung kwarto namin. Natulog ako sa labas na walang kumot, ay napakalamig. Ako po ay sinipon at inubo. Kaya kinabukasan, araw ng linggo, ay ako'y umuwi. Pagdating ko sa Maynila, ay masakit ng hawang ulo ko. Meron akong ubo at sipon at masakit ang aking throat. So, ako ay ipinatest, swab test, positive. Ako po naman natutuwa sa naging loyalty at malaking pagmamahal sa akin ng asawa ko. Tested negative siya. Hindi ako hiniwalayan. sabay kaming natutulog. Wala po kaming katulong. Siya ang nagluluto. Kaming dalawa lamang sa bahay. Hanggang 5 araw. Pero ako po ay nagkukonsulta sa doktor at binibigyan kami ng gamot na home remedies. On May 1, hindi na po ako makahinga sa bahay. That was on the 5th day since I was infected. So itinakbo po ako sa St. Luke's. Ako naman, hindi maswerte ako at hindi ako na COVID dahil may kakilala kami doon na nagreserba ng kwarto, diretso ako sa kwarto. Doon ko nalaman na si Atong Ang at si Erap Estrada ay na-COVID din at sila ay na-intubate at sila ay na-emergency. Awa ng Diyos, ako naman ho ay hindi. So, ako ho ay diretso sa kwarto at sinamahan ako ng aking manugang, si Attorney Nena De Leon, asawa ng aking bunsong anak. Ay sabi ko, ay bakit ka sasamang mag-alaga sa akin, ay ikaw ay hindi pa nababakunahan. Baka ikaw ay mahawa, hindi ka pa natatakot. O ang sabi naman niya, kung hindi kita sasamahan, ang sasama sa iyo si Johnny. Ay kung si Johnny naman ang madidisgrasya, kawaawa naman yung mga anak ko at kawaawa kami. Hindi bali na ako. Sasamahan kita. Sinamahan nga ako. Ngayon, nung ika-3 araw na naroon ako sa ospital, nagising ako ng 3:00. Nakita ko umiiyak. Nakikiramdam ako. Pagkatapos narinig ko, nagbibili na sa asawa na huwag pababayaan yung mga bata dahil umiiyak siya, na-COVID siya. Ang sabi ko, noon, halos hindi ako makahinga dahil, siyempre, ako, kinabahan ako, na-stress ako, biruin mo. Manugang ko, hindi ko naman kaano-ano, nagsasakripisyo sa akin. Tumagilid ako dahil yung mga doktor naman ay napakalimit pumunta sa akin dahil mga branch ko sila sa Scintilla Juris. Inalagaan nila ako. At tinuruan ako, pag ikaw nahihirapang huminga, tumagilid ka. Pag nahihirapan ka pa, dumapa ka, itaas mo ang iyong puwitan at pilitin mong huminga. Pag ikaw ay give up, mamamatay ka na. So, ganun nga ang nangyari. Hindi ako makahinga dahil ako na-stress. Nakita ko na umiiyak yung manugang ko at narinig ko na tinawagan yung asawa, nagbibili na. It was a choice. Gusto ko pang mabuhay, tiisin ko, napakasakit po. Napakasakit, hindi ka makahinga. Napakasakit ang buong katawan. Inisip ko na siguro pwede na naman akong mamatay dahil ano pa naman ang iniintay ko, maayos naman ang mga anak ko. Pero naisip ko, sa naging sakripisyo nila sa akin at naisip ko na maaring malaki ang pagkukulang ko sa asawa ko, kailangan nila ako, mapaglingkuran ko man ang asawa ko habang buhay dahil pag hindi ko siya minasahe ang likod at paa, hindi siya nakakatulog. Di yun sabi ko may pagpatuloy ko man lang yung ginagawa ko sa asawa ko. Diyos ko, ako po ay inyong buhayin. So lumaban ako, napakasakit. Kaya nung medyo naka-recover, I decided to fight it out. Tinawag ko yung manugang ko, sabi ko, huwag kang mag-alala, ipagagamot kita. Tiningnan niya yung aking oxygen level, 82. So, talagang critical period na. Ang tumawag kami ng sa nurse station. So, from level 1, ginawang level 4. So, yun, medyo naka-recover ako. Ngayon, yung doktor, ang advice sa kanya uminom ka ng gamot at gamot sa flu, paracetamol, gamot sa sipon, sa ubo, at bukas magpa-test ka. Kung positive pa rin, you have to be treated. Ay di, siyempre tinawag natin yung lahat ng santo. Ipinangako na yung lahat na pwedeng gawin. Pagbigyan laan tayo sa aking panalangin. Awa ng Diyos po, kinabukasan, negative siya. Di sabi ko, sige, umuwi ka na. Hindi, sabi niya, malapit na naman kayong lumabas, sasamahan ko na kayo. But my wife hired a caregiver at pinauwi na siya. So, umuwi na. Can you imagine? Hindi ko naman siya anak. Hindi ko kano-ano. Nagsakripisyo sa akin, itinaya ang kanyang buhay. Bakit naman hindi ako lalaban? Yun ang iniisip ko. At iyan po ay dadaan sa lahat ng mga nakausap ko na nagkaka-COVID. Kapag pinanghinaan ng loob at hindi na lumaban, ay talaga mamamatay na dahil mahirap po talagang huminga. Kaya dapat talaga babantayan natin ang oxygen. At ako naman nagpapasalamat at yung asawa ko hindi ako pinabayaan hanggang I am nursed back to health. At natutuwa ako na sinubukan kong mag-lecture kung ang aking mental faculty ay hindi naapektuhan ng COVID. At sa awa po naman ng Diyos, hindi po naman. Dahil I am telling this to older people, senior citizens like me, that there is a study that the brains continue to grow if it is in use even in ripe old age. At kung titingnan po natin, sina Victor Hugo, 82 years old, nag-asawa pa at nagkaanak pa. Ay mayroon din akong kapitbahay na 95 years old. Nag-asawa po at siging panganak. Kaya lamang nung mamatay siya, sige pa rin ang panganak ng kanyang asawa. Hindi, joke lang po. But seriously, the masterpieces were created by artists during their old age. Si Picasso po, ang kanyang mga paintings were created when he was over 90. At si Alexander Dumas, yung sumulat po ng The Count of Monte Cristo, matanda na rin po. At yung mga philosophers, kamukha ni na Confucius, at yung mga leader sa China, kung inyong titingnan po, ay sila ay mga senior. Pero maliwanag pa rin ang pag-iisip, still as sharp as can be, dahil po ginagamit nila ang kanilang pag-iisip. Ang sabi nga ni Alfred Lord Tennyson, "The world is an arch where through gleams the untraveled world. How dull it is to pose to make an end, to rust unvarnished, not to shine in use." Kaya po kung patuloy nating ginagamit ang ating isip, kahit sa old age, hindi tayo magkaka-Alzheimer. At meron ba kayong nakita na old professor na may Alzheimer? Wala po. Ang nagiging sakit lamang ng mga old poge, ng mga professor, constipation. At yun din ang gusto kong ibahagi dahil hindi po ninyo naitanong, ako health verbal advocate. Kailangan po lalo sa nagkakaedad at lalo sa COVID survivor na gaya ko, kailangan po ay uminom tayo ng bastanting tubig. Hindi ho bababa sa 9 na baso isang araw, pero huwag susubra sa 12. Masama din ho naman ang sobra ang tubig at marami naman hong mga anti-constipation. Kamukha ho nung asitaba. Yan ho ay very common. Yan ay pinamimigay ko na sa mga kaibigan ko na ang dahon ating nakakain, nakakata, hilaw. Yun ho ang genura type of asitaba. Kung kayo ay kumakain ng 3 dahon lang hanggang 5 araw-araw, hindi po tayo magkaka-constipation. At ang isa pa na ina-advise ko sa mga kaibigan ko ay yun hong papaya. Papaya ho ang magaling at saka dragon fruits. Dahil may study na ang seeds, yung mga buto, actually are anti-COVID. Lalo ho yung apricot sa Amerika, ay yan po ay anti-COVID. At doon naman sa katulad kong may edad, ang problema natin, lalong mga kalalakihan, ay yung prostate. Ang gamot ho diyan ay sili. Sili dahil yung binibili kong gamot sa Amerika na anti-prostate, tinignan ko kung saan ang gagaling. Yung pala ay puno ng isang malaking kahoy na ang bunga ay sili. Kaya pag uwi ko dito, dahil minsan I was diagnosed na may problema daw ako sa autopsy, hindi autopsy, biopsy. Sabi ko, teka muna, alam ko ang gamot dyan. Uuwi muna ako dahil pinag-aralan ko po ang lahat ng mga medicinal herbs. Ay di sili nga ang isang napag-aralan ko. Sabi ko, doon sa doktor ko sa Amerika, I will be back in 3 months. Kapag pag-apa itong aking prostate at kailangan i-biopsy, saka mo ako i-biopsy. Pero I'll be back in 3 months. Ay di pagpunta rito, umiiwas po ako sa matamis at umiiwas ako sa maalat dahil diyan ho sumasakit ang paa natin. Nakakarayo tayo pagka masyadong maalat at matamis. Kaya kaya po kumain ako ng maraming sili at ang akin pong ipinapalit sa tuyo ay suka. Suka, lemon, kalamansi at yun ho ang aking pampasarap sa ulam. When I went back to the United States, nagulat sila. Wala po akong problema sa prostate. Napakababa ang PSA ko. Ayun, sili lang po. Yan po ay intermission lamang. Ngayon, dito sa marami pa na tatalakayin tayo. Actually, ang aking inihanda sana ngayon I will go through the Constitution at as I go along giving you an overview ay yung mga important provisions ay na involved sa mga leading cases ang didiscussing ko. Dahil walong subject ito, ang iniisip ko na magiging tulong ko sa pre-legal education ay ganito. Ililista ko ang lahat ng importanteng principles and doctrines sa lahat ng subject. Yung mga itinanong na at paulit-ulit na itinatanong, aking ilalagay ang simple outline of the principles. Kasi kung matsimpuhan ninyo itinanong, alam nyo ang applicable provision, sigurado hong hindi kayo magkakamali. At ang isang paraan na ginagawa ko para matandaan ng aking mga estudyante pag ako'y nagmamakbar ay kung minsan ay minamali ko ang sagot. Kamukha nung yung unang makbar ay wala namang nagrereklamo sa akin, sa inyo. Sabihin niyo, ito, sinadya kong maliin ang sagot nung sabihin ko na where the owner of the negotiable warehouse receipt is claiming and the goods were stolen and the owner comes forward also claiming, what is the remedy? Sinadya ko pong sabihin na replevin para tingnan ko kung kayo nakikinig. Hindi po replevin, interpleader. Ngayon, pag ako ay nagtanong sa makbar at mali ang sagot ng estudyante at sinabi ko kung ano ang tama, hindi na ho sila magkakamali. Because from their own mistake, it will be etched permanently in their retentive subconscious memory. Hindi ho nila malilimutan. Bibigyan ko kayo ng sample, ha? Ito, mga borderline question to determine who will land in the top 10 or not. Kasi kung pagpasalaang sa bar, basta meron kayong adequate background of the law, papasaho kayo if you know how to answer. So ito, isang mga borderline question, ha? Ito, ganito. A. Shoots B. Misses hitting B. Instead, hits and kills C. Question. What is the crime or crimes committed? Kahit po sa UP, kahit sa Ateneo, ang sagot karamihan mali. Ang sagot ito, ang maling sagot. With respect to A, attempted homicide, because the offender commenced the commission of a felony but failed to perform all the acts of execution by reason other than his voluntary desistance. Tama po yun, pero mali tama ang principle, pero mali. And ito pa, ang sabi pa, and with respect to C, the crime is homicide. Tama naman pareho. Pero hindi tama ang sagot. Because the answer is found in Article 48 of the Revised Penal Code. Complex crime. When a single act results in the commission of a grave and less grave felony, it is a complex crime where the penalty for the higher crime, for the graver crime, will be imposed. And you should distinguish this from complex crime proper as defined in Book 2. Where on the occasion of robbery, rape is committed or homicide is committed, That is special complex crime. At dito, marami ang nagkakamali. Kaya, ang gagawin ko, if we have the time, I will give you an overview of all the important principles in each and every subject that are usually encountered in the bar exams. I have reviewed all the bar questions since the institution of the bar. Kaya alam ko yung mga itinatanong palagi dyan at yung mga unresolved issues na hanggang ngayon ay pinag-aawayan pa ng mga lecturers kasi iba-iba ang kanilang opinion because it is unresolved. So nung ibigay ko yung makbar na yan sa Davao on behalf of the UP Law Center sa criminal law, yung complex crime, ay di yun nga ang mali. Alam niyo, itinanong, nagtap sila sa bar that year dahil hindi nila malilimutan na ang sagot doon ay complex crime under Rule 48. At ito, nung kumuha ako ng bar, ay itinanong yan kasi noon, yung bombing sa Plaza Miranda, People versus Rojas, inihagis yung granada during the what's that public meeting the avance of the Liberal Party. Ngayon mayroong namatay pero marami ang nasugatan at marami ang si Eddie Ilarde naputulan ng paa. So itinanong yan, basahin ninyo ang sagot ko dito sa libro ko. Ito yung answer ko sa 1970 bar. Itinanong yung People versus Rojas. Ang sagot dyan, there is only one crime. Ang itinatanong ng bar examiner para lituhin kayo, what is the crime or crimes committed? O edi mamimislead kayo ba? Marami tinatanong, bakit crimes? Edi doon sa example ko nga, sasabihin as to be, attempted, as to see, homicide. Homicide nga, basta namatay, homicide. And criminal intent is not even required. Now, criminal intent becomes material because if that is not proven, the crime is only physical injuries. So the crime there is it's a complex crime under Rule 45. A single act results in two or more grave or less grave felonies. So the crime committed is murder with prostrated murder. Yun ang crime committed. Why? Because the means employed in the execution ensures that there will be no defense that may be put up. Can you imagine hurling a grenade during the meeting the avance? That is attended by treachery. Because means, method or form was employed to ensure the execution of the crime without opportunity of defense on the part of the offended party. Ito pa. Ito'y pinag-aawayan ng mga estudyante at mga lecturers na iba't iba ang pananaw. Pero ang aking itinuturo sa inyo kahit anong isagot nyo, as long as it is based on provisions of law, that's good enough. Kaya lang, pagka borderline, you may argue either way. Isa na lang dahil baka maubusan kayo ng oras. Ngayon, kung gusto nyo magpasikat, you present both sides. Make sure that you make an evaluation. And medyo mahirap yan. You have to evaluate the pros and cons for both sides before you can come up with a decision. Pero kailangan yan. Pag ako nagtanong, pag ako magiging examiner at ang pipiliin ko ay criminal law, kahit na civil law, ganito. Magbibigay ako ng problem. Pagkatapos as lawyer for the plaintiff, what will be your arguments? Number 2, as defense counsel or as counsel for the defendant, what would be your defenses? And then number 3, as judge, resolve the issues with reasons. Dahil yan ang training namin sa UP, that he is not a good lawyer who does not look at the issues from both sides. Dapat ay alam mo kung ano ang tatalo sa iyo at alam mo kung ano ang counter arguments mo. Sa criminal law, again, impossible crime. Remember that impossible crime will only apply in case of crimes against persons and property. Ngayon, pag hindi persons and property, walang impossible crime. And also remember, there is an impossible crime if the act is not punishable under other law or provisions. Ito ang example. A administers poison to B. B does not die because he is immune to poison. All right. What is the crime committed? Impossible crime or prostrated? Now, there is no other crime committed. If there is no other crime committed, then it is you can justify it under impossible crime because of the use of ineffectual means or inherent impossibility of killing a person who is immune from crime. So maybe it is the second ground, because a poison definitely is effectual to kill, except that there is impossibility of killing by poison a person who is immune from crime. As a professor, I will accept that. Now, alternative answer, prostrated. It is prostrated because A has performed all the acts of execution that would produce the felony intended, other than which did not materialize by reason or cause independent of his will. It fits also the definition of prostrated crime. So either two will be a good answer, because there is no decided case. Now, on the first case, there is a decided case, and which I believe is a wrong decision of the Supreme Court. The facts are simply this. A, believing that B is in his apartment, riddled the apartment with Armalite bullets. Luckily, B was not inside the room. What is the crime committed? Impossible crime? The decision of the Supreme Court said impossible crime because of the inherent impossibility of killing B who is not in the room. That was the decision. And in my book, I am criticizing that because there is damage to property, and that is malicious mischief. Or if it will fall under illegal discharge of firearms, then there is a crime committed. Because the moment that a crime has been committed, then an impossible crime is not the crime, but that other crime. And to me, the damage caused by the Armalite bullets on the apartment is damage to property, and that is malicious mischief. So I am criticizing that in my book. Now, here is another controversial case in the and this was luckily this was asked in the bar, and it was in my makbar when it was asked. A lady of the night, a hostess, on her way home, passed by a pharmacy who was open 24 hours and asked for a sanitary wash for her genital. The sleepy pharmacist gave muriatic acid instead of a sanitary wash. So the lady of the night washed her private part with muriatic acid. Question: what is the crime committed? This was asked in the bar. I was already a reviewer in UP and in Ateneo when this was asked in the bar, and we were able to guess that because that is always my joke when I was reviewing in criminal law. So what is the crime committed? Physical injuries. What are the possible defenses? Mistake of fact. But mistake of fact is exempting only where there is no negligence. Where there is negligence, then mistake of fact is not a complete absolutory exempting circumstance. However, there might be mitigating circumstance, lack of intent to commit so grave a wrong. So, the mind of a student of law, and also when they become lawyers, should always be open. And in the courtroom, you should be able to respond to the situation, exigency of the situation, because the moment that you hesitate, the judge will ask you to sit down. In any question in the bar, you are being tested for your ability for logical reasoning. And even if your reasons are not based on specific codal provisions, still you can get away and pass. I have a student in UP. I think this was in 2009 when Justice Leonen called me to handle review classes in UP, because before he became judge, I think 26% of UP certified graduates flunked the bar. So he called me and I handled review classes, and I said, to make it more worthwhile, give me assignments, core subject assignments, and I chose special contracts, the law on trust, because I wanted to make a deeper research and study of trust, because the principle of equity is involved on the chapter in Book 5 on trust. So I handled that in addition to review subjects. I had a student, a working student, a senior working student. I remember her name, Miss or Mrs., I'm not sure now, Benepayo. She's working. But she survived recitations. I'm sure at that time she was not prepared. But when I called on her to recite, she could recite, giving practical answers. So, because she was always absent, but as a teacher, I am not very concerned about attendance. As long as working students can pass my exam, I give them a grade. I remember a certain student of mine in 1972 in criminal law in Lyceum of the Philippines in Intramuros. He was an elected councilor in Pasay City. He's Councilor Bagaching. So, first day of class, he introduced himself as a councilor. And then I told him, I am not very particular about attendance. I give him the syllabus. You study very hard and just come here during the prelim, take the exam, and also the midterm and the finals. And if you pass, I'll give you a passing mark. And I also adapt that in the case of Miss Benipayo. She was absent most of the time because she was working. She was employed. When it was time, she was able to graduate. She was able to comply with the minimum average requirement of 2.75. But the dean would not allow her to pass, to take the exam, because he thought that he would not pass. She was always absent, was not studying. But she passed all the subjects and she complied with the minimum requirements. She was allowed to graduate, but not allowed to take the bar. So he consulted me and I told her, don't tell anybody you go to the Supreme Court, you file a petition to take the bar, and you tell them, I guarantee that you will pass the bar. Because I really believe that she would pass the bar because she can stand all my recitation. Every time that she was present, I would ask her to recite, and she did not even know the legal provisions involved, but she can manage by her wits. She was able to stand recitation. So I said, you will pass the bar. So she filed a petition to take the bar. It was set for oral argument before the court in Bank. And then one justice called me. Is it true that you guarantee that Ms. Benipayo will pass the bar? Yes, Justice. What if we cite you for contempt if she fails? You can cite me for contempt. I'm sure she will pass. She was allowed to take the bar. Now she's a lawyer. I have not seen her for a long while, even after passing the bar, but I knew that she passed the bar. And then I remember when I was a reviewer in Lyceum of the Philippines. We have a bar candidate who is 86 years old. She almost drowned because she fell on a manhole on the street before UE. It was there was a pour of heavy rains, and she fell on a manhole, but she was saved and took the bar and became a lawyer at 86. And then there is another number 9 graduate from the first batch of Sambeda here in Alabang. They put up a law school here, and the first graduate, one was a bar top notcher, and I believe he is 69 years old when he took the bar. So I believe that those who are working students have a better chance now, where there will be only 15 questions, all problems. So prepare to familiarize yourselves, to have adequate knowledge and background of the law. Now, if you do not know the answer, you just apply the natural principles of justice. And the principles of justice are based on the golden rule of right and wrong, that good faith is rewarded and may even be a defense. Bad faith or malice is penalized. That is the golden rule, and that is the law on equity, and that is what is meant by equity. And our courts are both a court of law or equity. Now, I will give you an example. I am being groomed as president of the World Slashers Alliance to conduct online sabong. My partners can put up the capital. So what happened was that the cockpit in Giginto, Bulacan were improved by us, and I believe the group spent 3 million pesos. Unfortunately, the local government refused to give a permit, so we have to transfer venue. And what happened to the 3 million? Can we not recover it? Under the principle of equity, the principle of unjust enrichment, we can recover. the 3 million. We can sue them to recover the 3 million because no person can be unjustly benefited at the expense of another. That is the principal rule of equity. Because the principle of equity does not apply to specific situations. There are only two main grounds or main principles on which equity is anchored. And number one is the principle against unjust enrichment. And number two is he who benefits from the services of another, even in the absence of an agreement, deserves to be compensated. So, it is called solutio in debite. That an example of that is during a storm, your neighbor spent to take care of your property. Even in the absence of a written agreement between the two of you, you must compensate your neighbor for the expenses that he incurred in protecting your property. Another example, a fire truck that has lost its brake system is running very fast and would hit a mansion. In order to avoid hitting the mansion, the driver veered the truck towards a shanty, destroying the shanty. Even if there is no agreement between the owner of the mansion and the owner of the shanty, the owner of the shanty is entitled to be reimbursed because that is equity. Because the owner of the mansion is benefited and therefore he must pay the compensation. Now, so that is unjust enrichment. The other principle on which equity is grounded is solutio in debite, and that is exemplified in the case of the Javier couple, who was supposed to receive only $1,000, but by mistake were deposited and remitted $1 million by Melon Bank, and the Javier couple kept and misappropriated the property, the 1 million. Despite the fact that the Melon Bank offered a compromise, just return 50% and we will forget all about it. But greed took hold of the Javier couple and they appropriated the entire 1 million. And there was even a lawyer who represented them. Now, let us look at estafa through breach of trust and confidence, or estafa for administration, estafa committed by deceit. Technically, there is no estafa by misappropriation, because if you will look at the elements of estafa through misappropriation, breach of trust, the money must have been properly delivered for in trust and for administration. And an example of that is sale of jewelry. To be sold, and if sold, to remit the purchase price, less commission, and if unsold, to return. It would not fall under that because there was no trust and confidence. So it cannot be breached of trust because there was no relationship between Melon Bank and the Javier couple. Estapa by deceit? No, because Javier couple did not employ means or method to get the money. There's no estapa. But again, exigency of the circumstances and equity. Because in equity, he who received something by mistake must return what he received. That is a cardinal principle of natural justice and equity. And so that was applied by the Supreme Court in the Javier case. Technically, there is no estapa because the distinction between estapa is that there is delivery. But there is no delivery. And in case of theft, there is taking without the knowledge and consent of the owner. So technically, the rule on estapa under Section 315 A and B of the revised penal code would not apply. But the Supreme Court applied equity. And what is that equity? He who receives something by mistake must return, because if he does not, that runs against the grain of unjust enrichment. So, even a final and executory judgment, if upon supervening events, you can prove that the execution of a final judgment would be unjust, oppressive, or iniquitous, you can alter the final judgment to conform with the facts and the paramount interest of justice. Again, yung sinasabi ko hindi loopholes. Ang itinuturo ko you should be able to correlate because the answer might be found in some other section. Kaya po ako, nung nagtuturo ako ng criminal law sa Ateneo, hindi ko hinahandle ang book 2. Dahil sa book 1, sinusummarize sa criminal law 1, ay itinuturo ko na what are the specific crimes under book 2 dahil hindi ho maiintindihan ng mga estudyante the general principles in book 1 kung hindi sila pamilyar sa specific crimes in book 2. Kaya sinasabi ko, yung mga estudyante ko na dumaan sa akin sa book 1, pwede na nga i-exempt sa book 2 dahil minaster na namin yung specific crimes. At saka, bakit nga ganun? Baliktad. Yung mga general principles, absolutory, mitigating, aggravating, etc. These are applied to the crimes specifically defined and penalized under book 2. Ay bakit inuuna yan? Ay di dapat ang unahin ay book 2. Kaya sa akin, ang inuuna kong ituro, sinusummarize ko by way of a lecture, the way I am doing it in pre-bar, ay masterin muna nila kung ano yung book 2 at kung ano yung mga special crimes. At madali na ang pag-aralan ang book 1. Ganun din sa negotiable instruments law. Ay, alam nyo, hindi nawawala ng question sa bar na walang negotiable instruments. Laging ang question dyan forgery problem. Oh, negotiable or not? Kaya yun ang itinuturo ko. Ngayon, kukumplituhin ko lang yung aking sinabi nung nakaraan na pinamemorize ko ang negotiable instruments. Ngayon, ang hindi ko lang natapos na sabihin ay ganito. Yung first 4 requisites that applies to a promissory note. Yung ikalima, that it is addressed to a drawee who must be named and specifically identified, indicated therein. Ngayon, kung hindi maliwanag yung drawee, then it is still valid as a promissory note. At doon sa sinabi ko na if there is a problem of forgery of payee signature, ang payee, ang pinords, sinabi ko na ang magbabayad ang drawee. Ay wala namang nagrereklamo sa inyo, mali yun. Ngayon sasabihin ko ang rules para sigurado na hindi kayo magkakamali. Ang rule na hindi ko sinabi. When there is a forged signature, parties prior to the forgery are released. Ngayon, between the bank and between the payee with forged signature, release ang drawer because he's a prior party. If there is subsequent negotiation and there is forgery of a signature of a party negotiating endorser, parties prior to the forgery are all discharged. That's a rule. If you will remember that, you will not be mistaken in answering problems in negotiable instrument. But we will go back to this when we have the time to have an overview in mercantile law. Now, between the payee whose signature is forged, if he is not the proximate cause, he would not be liable. He will win against the drawee bank. But anyway, the rule is this: the proximate cause, the person who is the proximate cause of the loss will bear the burden of loss. Ay, ano na pala, my daughter put a clock. So it's 20 to 12. Maybe I can be more of help if I write down the Makbar questions and I will put the applicable law and jurisprudence, and then let the students study. Now, some students are hesitant. Siguro nahihiya mag-submit sa akin ng answer. But when the University of Manila opens, you may see me there. And you see, I welcome reviewers from other schools when I am the reviewer, free of charge. When I was the bar review director in the Manila Law College, the auditorium is always full because I do not charge, and if they wish to Xerox my materials, I allow them, and I even allow them to Xerox this. Under the copyright law, if the purpose of reproducing is for personal use, there is no violation of copyright. So I allow. I have several books. Now, let me take advantage of the remaining time. Prescription. And we are still in criminal law because although criminal law supposed to be short because you have the revised penal code and special penal laws, compared to commercial law where you have many special commercial laws, and even the old code of commerce are still being subject of questions in the bar, like the old bulk sales law. But then, these are related to current law, like the corporation law. For example, the bulk sales law is involved in corporation law, where assets or substantially all the assets are being sold. So, in addition to the requirements of consent of the stockholders of the requisite majority, the bulk sales law must be complied with if since the corporation is involved. So there is a correlation between the bulk sales law and the corporation code. And one important area of novel amendment to the corporation code. Number one, a corporation sold may be organized by a single stockholder, although it is not being implemented because the implementing rules has not been released by the SEC. And number two, and this is very important to practitioner, when the life of the corporation has expired under the Articles of Incorporation, before the amendment, that is the end of the corporation. It has to be reincorporated after liquidation. Now, under the amendments, under the present administration, a corporation which has expired in its period of existence indicated in the articles may simply revive the legal personality, the corporate legal personality, by filing an amendments to the Articles of Incorporation extending the life of the corporation. And it doesn't matter that the amendment is made after the lapse of the 50-year period. Without the amendment, the rule is the corporation must be liquidated and the corporation has lost legal personality. But again, there is an exception because there is a winding up period. A corporation that has been delisted, or a corporation whose life has expired, period of existence has expired, has a 3-year winding period. And in the absence of the board of directors, the lawyer, by provision of law, is considered the trustee. Now, let us go to I still have 15 minutes before 12. The case of Maria Risa. Maria Risa was charged with libel under the revised penal code. The case was dismissed by the NBI on the ground that it has prescribed. The case was refiled with the DOJ. The DOJ filed a case under the cyber law for cybercrime. The period of prescription under the revised penal code is different. If it is libel under the revised penal code, it's a very short period. It has prescribed. Now, the period of prescription applicable to crimes punishable under special penal laws is different, and that is what we are going to discuss now. So this is the introductory chapter dedicated or devoted exclusively to the right of prescription. The different rules with respect to crimes punishable under the revised penal code, mostly called mala and se, and the prescriptive period for crimes punishable under special law, usually or generally called mala prohibita. The revised penal code does not apply to crimes punishable by special laws, on the law on prescription. The rule is this. The revised penal code will apply to crimes committed under the revised penal code. For crimes committed under special penal laws, the provisions of the revised penal code has suppletory application, meaning that the provisions of the revised penal code will apply only to crimes punishable by special penal laws on areas that are not provided or are not covered by the special penal laws. So that is the meaning of suppletory. Hindi. Now, in the revised penal code, a crime punishable by the revised penal code has a prescriptive period which is suspended when number one, a case is filed in court, and number two, when the accused flees the country. Now, under the special law, now let me see what act is that. Act number 3326, governing prescription of offenses for violation of special penal laws. The period of prescription is suspended only upon filing of the information in court. Now, fleeing the country is not a ground to suspend. Now, in the case that I am citing here, and I would like you to read, Romualdez versus Marcelo, 497 Iskra 89 2006 decision. Cocoy Romualdez fled the country when Cory Aquino ascended into power. He came back and he was charged for Anti-Graft and Corrupt Practices Act. Now, the issue is whether the crime has prescribed or not. If we apply the revised penal code, fleeing the country suspends the prescriptive period. That is found in the revised penal code, which is applicable only to crimes punishable under the revised penal code. Under the special law penalizing crimes punishable under special law, fleeing the country is not a ground to suspend prescription. Related doctrine is the doctrine of pro reo, that criminal laws are construed strictly against the state and favorably to the accused. Since the period of prescription applicable to crimes punishable under special penal laws does not provide fleeing the country, which is in the revised penal code, does not provide fleeing from the country as a ground for suspending the period of prescription for crimes committed under the Anti-Graft and Corrupt Practices Act, because it is a special law. And so this act, this special law should apply. And please read the case of Romualdez versus Marcelo, and you can see all the arguments in the Supreme Court. I would not say copied, but were adapted here, because I was the counsel who filed the second MR. And it was accepted by the Supreme Court. Going back to the case of Maria Risa, so she was convicted by the RTC, applying the prescriptive period under the cyber law. But I believe that libel under the revised penal code and libel under the cyber law is the same dog with a different collar. And the principle of pro reo, I think, should grant the benefit of prescription in favor of Maria Risa. Because even if it is a cybercrime, it is only the means of committing the crime that is different. And so, to me, that is an artificial distinction that would not make for a real differences to justify a different treatment on the issue of prescription. So that is what I intend to do. The per questions and involving the recurrent principles uh, also ask in different forms. What I will do is list down all the important principles in each and every subject, because I have updates on all the 8 subjects of the bar, and I give I cannot be heard anymore. Connection daw, connection.
Daddy, wag mo ano, urong ka.
Tanong mo, baka hindi na nila ako naririnig.
Ano yung sabi nila sa'yo?
Sige, ganito, we have barely 5 minutes. What I would like to announce is that I will be sending through Messenger a list in each bar subject, important principles and leading cases that I would like the students or the bar reviewers to read, so that maybe they will better appreciate when I make an oral presentation. And anyway, if we will open already the schools in you are free to visit me there. I will not charge you. If I am the lecturer in any school, I allow friends to join. So that is what we will do. So I think that that will be all for now. If our admin, Rose Kalakala, has a specific request from any students for me to discuss and take up, I can be reached in Messenger. Facebook. So that will be all for now. We will see you next Saturday for more updates on legal current events. And anyway, we are discussing this as independent citizens, favoring no one, whether the administration or the opposition. So until next Saturday, and I'm even thinking we can still do this midway, middle of the week.
Integration.
That's why I was asking Rose the other day. I think that was Tuesday, that I wanted to discuss something that is happening in the Senate, and she said the most appropriate is on Saturday. So if there is a special request on any overview lecture on any subject, I will be available as long as I'm here and I am not in the farm. Anyway, during this lockdown, we are careful to stay home. Now, maybe I can start with the amendments to legislation like the Corporation Code. And most important also, the amendments to the revised rules of civil procedure, to the rules of court on under the circular of the Supreme Court that became effective May 20, 2019. I think even if that is not within the coverage, since the basic laws have been amended, and also the recent amendments to the Judiciary Act of 1948 on the cut-off of the jurisdiction of the first level court with respect to real property based on assessed value in the tax deck, and also for the recovery of a sum of money which has been raised to 2 million. I think that if you are asked a question, I think you have to apply this because these are very important. Now it is 12 o'clock, so we have finished the 3 hours. Anyway, I am used to whole day without interruption in my seminar, and I am glad that despite my being a COVID survivor, I can still do it. So we'll see you next time.